Good afternoon. Welcome on in to another episode of From Day One. This afternoon we have a very drunk, nice defendant who doesn't like his current sentence.
Here on the record today for the 28th Circuit Court for Western County. We are taking up the case of the people of the state of Michigan versus Blake Adam Carlton Hughes. This is file 23-13481 FH. Appearances from counsel, please.
Good afternoon, Your Honor. Corey Wiggins on behalf of the people.
Hey, good afternoon, Your Honor. Philip Komorski. I'm appearing on behalf of Zoom on behalf of my client, Blake Hughes.
Thank you. Mr. Komorski appears via Zoom today, and joining us via Zoom from Michigan Department of Corrections is Mr. Hughes. Mr. Hughes, are you able to see and hear the court today, sir?
Yes, Your Honor.
Thank you. Right. We are here today for a post-trial, post-sentencing motion filed by the defense pursuant to MCR 6.310 parenthetical C, closed parenthetical, which is a motion to withdraw a plea, which is being heard within 6 months of the sentence. I turn over the argument to Mr. Komorski.
Thank you, Your Honor. Won't belabor too much since my brief. I know Your Honor has gone over it thoroughly, and I won't repeat a lot of it. But basically, the main thrust of our motion is that when Mr. Hughes was deciding to plead guilty, and when he ultimately presented himself for the plea before Your Honor, he was not properly advised of the fact that this particular charge, OYL third per se, carried a mandatory. He was advised by Your Honor on the record of the potential penalties of 1 to 5 or 30 to whatever days in jail plus probation. The problem with that advice on the record was there was no mention of the prison being mandatory, and I think it was.
It's not mandatory, isn't it? Either or. It's either a period of 1 to 5 years or a period of probation of 30 days or more. There isn't a mandatory prison.
There is a mandatory provision if Your Honor decides to do in imposing the prison sentence.
How did I not tell him that it was 1 to 5?
You told him that it was 1 to 5, but as with any statute that a defendant is advised of, there's always the time that's advised, which is the maximum. Like, for instance, assault with intention to great bodily harm is punishable by 10 years. Receiving a killing is punishable by 5 years. But those terms are not mandatory. In this case, the 1 to 5 that he is advised of is mandatory, and it's our position that without advising him of the fact that if he receives the prison alternative, that it is a mandatory 1 to 5, that was what created this.
But if I tell him it's 1 to 5, how is there any discretion? I'm applying some common sense here. Maybe that's something that you're not doing. I told him exactly what the felony information said, that it is either 1 to 5 years of confinement or a term of probation with a minimum of 30 days. If I had told you that it costs you at least $1,000 to get out of jail, or I told you to get out of jail, you got to pay $1,000 to $5,000. You know the minimum is $1,000. How does that not tell him a minimum of 1 to 5?
Because it tells him what the statute is saying, much like the examples I use that say what the maximum prison time term is on any given charge. It does not mean in those other statutes that prison is required. In fact, GBH can require probation. What needed to be made aware of both by Your Honor and his counsel was that in the event that this court decided to impose the prison sentence, he needed to be made aware of the fact that that was the mandate of 1 to 5 and possibly even more on the minimum.
And did you have any, besides because I believe that I told him it is a minimum of 1 year to 5 years confinement. How did I not tell them that? Or do this. Show me a case where it says that in this instance I have to say the words mandatory minimum and mandatory minimum.
I don't have a case that says that specifically, but again,
there goes that argument.
Okay.
There goes that argument. Okay. All right. So I did tell him it was 1 to 5 years or a probationary period with 30 days to 1 year. So I did tell him exactly what the punishment was. And it doesn't take a whole lot of stretch of intelligence to figure out that when somebody tells you it's 1 to 5, the minimum starts at 1. All right, let's go on to the next argument. The next argument is something regarding Mr. Hartel. And I'm sorry, the statement about, what was the next argument? The next argument is regarding,
resentencing.
The sentencing. So
yes.
let's go ahead and turn to that argument.
Certainly. And again, it's our position that at the time of sentencing, it seemed like the focus of the prosecutor and ultimately the sentence that was imposed, it just dealt primarily with punishment and didn't really go to rehabilitating what the problem is in the first place. It's always been my position, Your Honor, in these cases that alcoholism and drunk driving numerous times caused by alcoholism is a public health issue. It needs to be addressed as a public health issue as opposed to throwing the individual in prison, because I don't think
what's wrong with prison? Aren't there rehab programs in prison versus what there are in jail? I've just recently had lectures. In fact, the entire judiciary of the state of Michigan met in Grand Rapids about 2 months ago, and one of our lectures was from the Department of Health or Department of Corrections about all the programming they have. So do they not have?
I'm sorry.
Yeah. No, it's okay.
I do acknowledge they have programming in there, Judge, but not the type of programming that you can get outside where you actually take it on yourself as the defendant to A, admit that you have a problem, B, get yourself into treatment. I don't mean just go to I speak. I mean get yourself into it get yourself a sponsor, go to AA 5 or 6 times a week, if not more. Only then can you start undoing the damage as the defendant, because I think as we've seen in these types of cases time and time again, that if you just force someone into a program, that they really don't complete it. They just backslide. And I think in this case, the comments I saw Mr. Hughes make at the time of sentencing, he was willing and able and attempting to take matters into his own hand and accept responsibility, which I think is number one in a case like this when you're dealing with alcoholism. And I would ask the court to give him the opportunity, because if in fact he does not comply, this court always can, with a stroke of the pen, yank him back and send him back to prison. And
so let me, and here's why I approach it the way I am. Your first argument is a motion to withdraw the plea, which is pursuant to MCR 6.310. So that would apply to your first argument. This argument is actually not made, can't be made underneath 6.310. So what rule are you making this argument under?
I'm just making this argument as a post-conviction argument.
Relief from, all right, so this is a motion for relief from judgment.
Yes.
Let me take a look. All right. And so what are the grounds for the relief from judgment here? In other words, do you think there was something that was done incorrectly? Or are you just re-arguing what you think should have been argued at sentencing?
No, I think what was done incorrectly was there are certain factors that need to be focused on when imposing sentence and arguing for sentence. And one of them is rehabilitation, which I think was totally overlooked. I'm not trying to place blame on anybody here, but I think the fact of the matter is that's what this man really needs, rehabilitation. Because let's take a look at it. He's been in and out of jail. He's been
he has failed probation repeatedly. And according to the pre-sentence investigation report, he had some substance abuse treatment at Catholic Human Services, which he had completed, and that was earlier this year. I understand he was currently seeing Catholic Human Services at the jail. So it looks like and I'm pretty sure, I know I took this all into consideration. I know that because I've got the pre-sentence investigation report in front of me, and I've got all the blue ink that I have where I've circled every single one of this as violations of probation. He's had multiple drinking and driving. He's had multiple convictions. He's had multiple probationary periods. He's had multiple periods of jail, and he's had multiple probation violations and has failed several attempts at rehabilitation. That was my reasoning for placing him into a prison term. So I don't understand. It just seems like what you're doing is arguing that I should have taken some other things into consideration. I should have done something else. Now, let's take a look here also. One of the things that you didn't cite or reference is that during the taking of the plea, I asked the defendant if he had been promised and if Mr. Hartel had told him exactly what the sentence would be. And his answer was no. So I don't understand what the argument is, but go ahead and continue to argue.
That I've pretty much summed up my argument, Your Honor. And as far as the issue regarding the question of potential coercion and so forth, I cited in my brief where I believe it was the Court of Appeals that said even a conclusory statement by the defendant does not preclude the defendant from arguing that on a post-conviction motion.
And what is he arguing now?
That he was not. I'm sorry.
No, that's all right. Go ahead, sir.
That he was not properly advised of the potential time constraints that he was putting himself into when he was entering the plea. That he was actually advised something totally different by his lawyer.
One moment.
Yes.
Mr. Wiggins, your argument, sir.
Thank you, Your Honor. I guess I'll take these in the same order the court did. So in regards to the mandatory sentence, I think what the argument is there is that he wasn't advised that if he was sentenced to 1 to 5, it would be a prison term, not a jail term. That's how I interpret the argument. I don't know if I'm right on that, but I don't see that. The fact that where they serve the sentence, I don't believe is.
I didn't see any case law of the fact that I have to tell them it's either prison or jail. I have to tell them it's 1 to 5 years, which is exactly what I told them.
And I would agree with that, Your Honor.
It is. I've got this. I've got the transcript in front of me, and I read it verbatim earlier. I told him that he faced 1 to 5 years.
Moving on to the sentence, the rehab, I wonder what more we could have done. He was, as the court's already referenced, he was placed in the sobriety court. He was in that court for a period of time and then absconded for a year. He was in absconding status when he was picked up on the new charge that he was sentenced for. As the court referenced during sentencing, I believe he had 10 or 12 probation violations over the last 10 years. And not to make light of the situation, but when everybody's locked up, everybody wants rehab. Everybody's ready for a change at that point. And I think what more we could have done, especially as the sobriety court is designed to be an intensive rehabilitation program, I don't know what more we could have done. So I don't believe there's a claim there. I believe the court, I believe the sentence was appropriate. Moving on to an effective assistance to counsel claim, I don't believe, I did not receive the affidavit, but at least based on the statements contained in the brief citing the affidavit, it's clear that Mr. Hughes was aware that he was facing a prison sentence. It's argued that something to the effect that if the defendant had entered a plea that day, he was advised by his client, by his attorney, that he would likely receive a jail sentence. And I think to show that the attorney didn't give bad advice, that was just mistaken in what he thought the court would impose as a sentence, that matches up with what the Department of Corrections recommendation was. So I don't believe that rises to the level of ineffective assistance of counsel. The attorney was just wrong in what he considered the advice or what he thought the court was sentenced to. I don't believe that the defendant has made an argument as to his claims. I don't believe granting the motion would be appropriate at this time. I think it should be denied. If the court does believe that there is a question on whether there is an effective assistance of counsel claim, I believe it would be appropriate to set it for a hearing and hear from Mr. Hartzell. Thank you.
Court said the following during the taking of the plea. Quote, Mr. Hartel has probably discussed with you the Michigan sentencing guidelines, applied his experience, and given you an idea or estimate as to what he thinks the court might sentence you to. My question for you is, has he or anyone promised you exactly what the sentence would be from the court? Mr. Hughes said, no, Your Honor. Then I said, quote, knowing all that, do you still wish to enter the plea of guilty to count 2, operating on intoxicated as a third offender? His answer was, quote, yes, Your Honor. I asked him if he had made any promises, threats, or inducements. The answer was no. And again, I asked him if anybody had promised him what the sentence would be other than giving him guidelines and estimates. The answer was no. The court took into consideration the entirety of the pre-sentence investigation report. And again, the pre-sentence investigation report demonstrates that the defendant has a significant substance abuse problem. The defendant has had the opportunity at sobriety court and failed the program. The defendant had been given periods of jail. The defendant had been given opportunities of probation. The defendant had violated probation at least 10 times. In fact, each one of the drinking and driving listed on the CFJ 284 section. On the drinking and driving that I do see, violated probation on each one of them is discharged unsuccessfully. Again, the court believes that it provided one. I don't find that 1 to 5 is a mandatory minimum. I believe that there's a choice. In fact, the language stated on the record by the court is that there is a choice. Again, the court finds that it stated to the defendant at the taking of the plea that you're charged, quote, you're charged as a third operating while intoxicated felony. That increases the punishment to a minimum of $500 to $5,000 plus either 1 to 5 years of confinement or a term of probation with a minimum of 30 days to 1 year in jail and and at least 40 hours must be served consecutively. Plus there would be 60 to 180 hours, that should have been days of community service. So the only thing I advised him incorrectly of was of the days of community service. I said hours instead of days. The court did advise the defendant that it was 1 to 5 years. That I would also assume was disclosed to the defendant when he received a copy of the felony complaint, which he acknowledged in the file. And in the felony information includes that information of what the maximum punishment, what the minimum maximum punishments are, and that the defendant was advised of that also during the arraignment at the district court level. And there was even a preliminary examination that I see in the file. I can understand and respect the fact that Mr. Hughes is disappointed with the sentence of the court. The sentence that the court gave was lawful. It was in the middle, actually at the bottom end of the guideline range. And the court therefore denies the defendant's motions. Mr. Wiggins, could you please draft an order to that effect?
Yes, Your Honor.
Thank you.
Thank you.
Thank you.
exactly where he deserves to be. If he wasn't drinking and driving and continuing to drink and drive, he wouldn't be in prison. But at least in prison, he's not drinking and driving and he's not killing someone. So he's exactly where he should be, in my opinion. Let me know what you think.
Thank you, my dear. A new person to the channel. We definitely appreciate them. With that, we'll bring this afternoon to a close. As always, please make sure you like, share, and subscribe. Be kind to one another. And release the Kraken as we march along this afternoon and every afternoon here from day one. Have a great afternoon. We'll see you.